My name is Yvonne Rosenkranz and I am the facilitator for this evening. This webinar is entitled The Role of a Coroner Explained. And this webinar will provide practical information on the role of a coroner and on the law, the standards and the procedures that apply at inquests for a person who died by suicide and or suspected suicide. Our guest speaker is solicitor and now retired Mayo coroner Pat O'Connell, who has over 45 years of experience of working in the Coronial Service, including serving as the coroner for the District of Mayo from 2016 to 2024. And we also have Garda Stephen Emmett from Store Street Garda Station, a family liaison officer with us this evening. And we will close the webinar with information on suicide bereavement and support services from HUGG. So I have the pleasure now of inviting our first speaker for this evening, Garda Síochána Liaison Officer Stephen Emmett. Sorry, Stephen. Hi, Stephen.
I'm having awful trouble getting my mic working. How are things, Yvonne? How are you?
I'm good, thank you. And you're very welcome this evening. It's lovely.
Thank you.
And my first question already for you, and it is, what is the overall role of a Garda liaison officer, and does it depend on where you live?
Yes, the overall role of a Garda liaison officer is to deal with the families of serious incidents. The most common incident we deal with are very serious road traffic accidents, fatal collisions and murders. I would be dealing a lot with being in the roads policing end. I'd be dealing a lot with the road traffic collisions and families who have been bereaved due to accidents in the North City Centre. So what we do is we are appointed by the senior investigating officer, which is either a superintendent or detective superintendent, and we then go and meet the families. We give as much support as we can to the families, and we try and give them as much information on whatever they need. If they wanted information on how their loved ones have passed or whatever they want, we will try and give them, as long as it doesn't affect the investigation. We help them, give them information on different support systems and different support networks, and we also then liaise with the coroner. We try and make the process as easy as possible for them. We contact the coroner, and sometimes there's a problem getting bodies released and stuff like that, and we will try and get as much information, whatever information the coroner needs to get bodies released. So,
right, can I ask you, in the role of the Gardaí, when a sudden death occurs due to unnatural causes, which is considered a suspected suicide?
We wouldn't. Again, it's up to, every case is taken on its merits and on the details, but it's up to a senior investigating officer to decide whether an FLO is appointed to a suicide. I haven't heard of any in the North City Centre. I can only give my what I have seen over the last number of years. I've been doing the flow role for the last 6 years, and I've never been asked to do one. But again, it's up to each individual incident for a senior investigating officer to decide to put a flow in for that incident.
Okay, yeah. So it's not one specific. It will be taken to the next step.
No, where there's a murder or a road traffic collision, there is one, because it's a long investigation.
Right.
Because if it may take many months or years, so we will be with the family for the duration of the investigation, up to the point where, if there is criminal proceedings, we will be there at the criminal proceedings, and if it just goes to the coroner's court, we were there at the end of the coroner's court's proceedings.
Okay. Oh, thanks, Stephen. And when does a Garda family liaison officer become involved with the family of a person who has died by suspected suicide?
It is only when a senior investigating officer has appointed it. Again, it's on the merits of each case.
Yeah, so there's always a senior investigation officer who decides then whether or not specifically suicide, and that's dealt with differently. Would they
Yes,
then they'd have a separate family?
That's the only way we can be appointed, is if a superintendent asks us to step up to the role.
Okay. And how do you see your role overall? You mentioned there about that you see every different type of case. Does it depend on where you live?
No, it does. There shouldn't depend on where you live. Each division and district has FLOs in it, and they're spread out throughout the country. There is a number of trained FLOs in every district and division, so it should make no difference whether from one end of the country to the other. You should receive the same service as you do in the cities.
Okay, and then in the end, at the end of it all, then when it's an unnatural cause, it's not specified until the senior officer takes it separately.
Yes, well, when a guard arrives at the scene, they go and they do an investigation. I understand that it can be traumatic when guards arrive at your door after having a bereavement like that, but once they're called, they have to come to it and they have to have a look and see and make sure that there is nobody else involved or that it is suicide. Once that's done, they then go back to the station and fill out the paperwork. They call a C71 and send it to the coroner, and then they could be asked later down the line as well to do a formal identification, and they do a file up for the senior investigating officer to detail what has happened, and then it's up to him or her to make the decision whether a FLO is given to the case or not.
Okay. Thank you very much for that. And when you is there anything you want to add to that? Anything?
No, I think we've covered everything, but I'll be on here later on. If you think of anything, I'll stay here until the end of the webinar. If there's anything else that's touched on.
We can ask you if there's anything towards the end, because as we speak to Pat, things might crop up. Will it be okay to get clarification from you?
Absolutely.
Okay. All right. Well, I will leave it there for the moment, Stephen, and thank you very much for that information.
Thank you.
We'll speak to you later. Thank you.
Thank you.
So thank you very much to Stephen. And now I'd like to introduce our main speaker for this evening, to invite you to Patrick O'Connor. Hello, Patrick.
Good evening, Yvonne, and good evening, everybody who's listening in and plugged into this webinar this evening.
Thank you very much. You're very, very welcome this evening. And I'm going to go, Patrick, first, if it's okay, just to say a little bit about you, that you are a solicitor and now retired coroner, as we already said, with over 45 years experience. And you're also a former president of the Law Society of Ireland and served as a council member of the Coroner Society of Ireland from 2006 to 24. And you're also an author of a handbook for coroners in the Republic of Ireland. So you have a lot of experience, and it's very, very, it's a pleasure to have you this evening and to have all your experience to share with the people listening. So is it okay if I go straight to the first question?
Yes, of course, indeed. Thank you for that introduction.
Okay, and the first is, what is the role of a coroner?
The first thing I'm going to talk about in very broad general terms, because while I appreciate that this webinar is specifically geared towards suicide, it is important to understand what the role of a coroner is. It's not limited to death by suicide. The role of a coroner, the coroner's is a judicial personage, a quasi-judicial personage. It's very old. It goes back over 1,000 years. But for tonight's purpose, just to say that the coroners are governed by the law in this country from 1962 through to 2024. and that's a sort of a codification of a law. There have been some judicial cases as well, which I won't go into in detail, but we may discuss it at a later stage. The Coroner Service is a network of coroners located throughout the country. The coroners are either qualified doctors or lawyers, so they must be either a doctor or a lawyer being a solicitor or a barrister, obviously a number of years practice. And the job is to look into the circumstances of a sudden, unexplained, violent or unnatural death, so that a death certificate can be issued. And this may require a post-mortem examination, which I'll come to later, and sometimes followed by an inquest. Coroners are organised by districts, usually in accordance with local authority. The Coroner Service is funded by the local authorities, that's the county councils, except in the case of Dublin, which is funded directly by the Department of Justice. At present, there are approximately 27 coroners in the country. The numbers have been reducing over the last few decades as districts are amalgamated and as there are proposals to change the whole coronial system in the country, which I don't propose to go into now, but at a later stage it may arise. And the names and addresses, and this is important, the names, addresses and contact details of coroners can be obtained either from the local authority, that's the county council, or on two websites, and I'm purposely bringing them to the forefront as people may, for whatever reason, have to drop off. But the two websites that I would draw their attention to is www.coroners.ie or www.dublincoronerscourt.ie. There are other websites as well, but they're the two key websites, and if anyone wishes to obtain details or more information in relation to coroners and where they're located, that's the way to look at them, and to most people are computer literate nowadays. Coroners provide an important public service to the living, and particularly to the next of kin and family and other people affected by a death. They not only help to bring this awful word closure to the bereaved, a person who's bereaved suddenly, but they also perform a wider public service by identifying matters of public interest that can and have life and death consequences, and also some learnings for public at a later stage. Now, coroners, that's my former colleagues, I'm retired just for 6 months at this stage, but I know that they all appreciate that the procedures involved in an inquest, though necessary, may involve upset for the next of kin and family of and friends, indeed, of a deceased person. And coroners do, in so far as it is possible, carry out their work as sensitively as possible. So overall, there, as I say, a number of coroners in the country. There is no unification of the actual process or procedures, but by and large, there is a body called the Coroner Society of Ireland, who have education days and bring coroners together to educate them, so that there is a general procedure that is followed by coroners in a coroner's court when there's an inquest.
Thank you very much, Patrick. And what is an inquest directed by a coroner?
Well, I suppose that the best way of starting it is what usually happens in the first 24 hours where there is a sudden death. Well, a sudden or unnatural, violent or unexplained death have to be reported to the coroner. Now, doctors or undertakers or registrars of deaths, or any householder where a person has died, or an institution where that person who has died was residing at the time of death, have to inform the coroner by law. Usually the death is reported to the Garda in the first instance, who will then inform the coroner of the actual death. And then what usually happens in the first, say, 24 hours of a death being reported? Well, first of all, as I said, all sudden, unexplained or violent deaths are reported, again, usually by the Garda to the coroner. The deceased may be taken to a hospital, mortuary or a funeral home until the coroner makes a decision if a post-mortem is needed. Then a family member may be asked to identify the actual body of the person, and that's very, very difficult and very traumatic for anyone, I appreciate. And the Gardaí may contact the person to get information about the circumstances surrounding the death. And then there may be also a necessity to obtain medical information. So when all of that has been collated, a form, it's called a Form C71, is submitted by the Gardaí who are to the coroner. And the coroner must then make a decision as to whether or not it's necessary to have a post-mortem examination carried out on the body of the person who has passed away. That's always very, very sensitive, but in not all cases on deaths reported to coroners is a post-mortem examination directed. For example, if a medical doctor is prepared to certify the medical cause of death, then it's not necessary to have, by and large, a post-mortem examination. However, in the context of what we're talking about this evening, death by suicide, it is always necessary to have a post-mortem examination carried out. The post-mortem examination is carried out by a pathologist in one of the local hospitals, and that is done as sensitively as possible, but it's extremely difficult. But the body of the person is brought to the hospital, and then the pathologist, that's a consultant pathologist, who's a specialist in dealing with the post-mortem, will carry out an examination of the person who's passed away, and then eventually prepare a report and send it to the coroner. There may be considerable delays in that, and I know there are questions later on relating to delays in getting reports and indeed holding inquests. So that's the broad parameters of what sets in motion the death that is reported to the coroner and what the coroner does when the actual death is reported.
And what is the purpose of an inquest?
Well, the purpose of an inquest is to identify the person who has passed away and how, when, and where that person has passed away. And as a result of a change in the law in 2019, where the coroner deems it appropriate to investigate the circumstances of a person's passing away. And then following that, then the coroner issues a certificate as to the medical cause of death. But that will follow, in the case of a death by suicide, follow an inquest being held by the coroner. So again, just to go back to the early stages, where the pathologist has carried out the examination on the body of the person who has passed away, and when the pathologist is in a position to furnish the report to the coroner, and it is the coroner who gets the report. It is not the family, or it is not the Garda, it is the coroner who gets the report. That report then forms the basis and helps to form the basis of whether or not an inquest is being held. Now, the post-mortem examination leads to a report by the pathologist, but it can be delayed waiting for what's called toxicology reports. So where there might be perhaps alcohol or drugs or otherwise involved, or there might be a suspicion that there may be, then the pathologist will refer the samples to the state laboratory. And the state laboratory, unfortunately, they say, as I accept that they are underfunded, but there can be considerable delays from anything up to 4 to 6 months in getting those reports back. And until such time as those reports on the toxicology will go back, and the analysis of those reports go back to the pathologist can't really finalize their report to furnish to the coroner.
Yeah, and that can take a very long time. It's before nothing can be done until those. Is that correct? Until the toxicology.
Well, something can be done insofar as the coroner may issue what's called a certificate as to the fact of death. It's often colloquially called an interim death certificate, and that basically identifies that a person has passed away, that where that person has passed away, the date that they've passed away, and to also set out that there are investigations that will be ongoing that may lead to an inquest at a later stage. But that certificate, that interim death certificate, is readily available from the local coroner, which can help the family and next of kin to get on with dealing with certain matters that arise relating to a death. For example, death grants or financial institutions, or indeed where a person has died in the country and they have to be brought out, or the body has to be brought out of the country. It is necessary to have an interim death certificate. But the actual state death certificate, that's the certificate that's issued by the General Central Register Office, that is not available until such time as the coroner signs a certificate, either after an inquest, where there has been an inquest, or where there hasn't been an inquest, where the certificate is furnished. Then the certificate, the death certificate, can be issued from the local registry office. The cost of that is €20.
That's very valuable information. That interim can be a source of help in the waiting, because it must be very difficult to wait so long for toxicology. Yes. Yeah. And Pat, who notifies the bereaved family of when the inquest will take place? And is there no standard procedure for identifying who within a family should be contacted? And this, it may rise to the questions of whether all appropriate family members have in fact been made aware of the inquest. Do everybody get notified, or is only specific members of the family?
Well, a lot of questions there that sort of need to be clarified. The law has been clarified insofar as that a family member of the deceased must be notified, but it doesn't specify who that family member is. Now, I appreciate that can cause difficulties, particularly in sort of multi-relationship circumstances where, or indeed where there are issues within families, which family member is notified. Unfortunately, the coroner can't make that decision, but all the coroner can do is identify a person or person within the family who is most likely to wish to have notification of when an inquest is likely to be held. Now, an inquest, notice of the inquest, again, this has been clarified in the last few years in the 2019 Act. The notification of an inquest must be furnished by the coroner, either in post or otherwise, either personally or through somebody else. Generally, it's the Garda that do it, and must give, insofar as it's possible, 14 days notice of the holding of an inquest. Now, there can be exceptions. For example, if somebody dies in the country and the family wish to have the body moved out of the country, an inquest might be held without giving the full 14 days notice. By and large, 14 days notice should be given, or at least 14 days notice. The coroner can do that themselves, or generally it is delegated to, delegated to the local Garda, who are extremely helpful in relation to that, and who have had a liaison with the person themselves.
Yeah, and that, so, just to clarify, it can be any family. It doesn't specify which member of family, but would it, but it won't be a partner or somebody that's not, if somebody was living with somebody, would it be seen as, or how would that?
That's always a very difficult question. I mean, quite frankly, I suppose in the past, it was relatively easy to identify who it was that should be notified. For example, people were married, but then the surviving spouse, husband or wife, or if there are children in the family, where there are partnerships, and they're increasing, of course, either unmarried or they're still in partnerships and they're living together for quite some time. I personally would regard the partner as being the person, a member of the family. But if there was a doubt, if there are children, well, then one of the children are the person to, provided, of course, that they're of full age, are identified. Difficulties can arise where, as I say, there have been relationships. Those relationships were broken down, where one of the partners is now living with another person and there's another family involved. Which person do you notify? The difficulty is that the coroner doesn't want to get into the controversy that might exist, but at the same time is conscious that it can cause and pose considerable difficulties. But what the law says, and I think it's section 28 of the Act, says that a family member must be notified.
Okay, and that leads me to this question, Pat, is how can a person outside of the immediate family, example a former partner who wishes to attend the inquest of their loved one, seek information around the time, date and place of the inquest? How would they find out?
All right. Well, first of all, I suppose in general, inquests, if they're directed, and I'll come back to the procedure in relation to an inquest and how it's conducted, because of the question that was there earlier on. But if an inquest is directed, an inquest is held in public. So every member of the public is entitled to attend the hearing of the inquest. That can, in some circumstances, be sensitive for family members, but the law is quite clear that an inquest, because it's in the public interest, is open to all members of the public. So therefore, former members of families or partners or otherwise are clearly entitled to attend the inquest. Now, the question is, how do they know that the inquest is coming up? Well, that's something that unfortunately they have to either find out from a family member or indeed from the coroner's office. The coroners will be very open about holding an inquest, because at the end of the day, the inquest is going to be held in public anyway. So there's no secret. In my case, I used to always prepare a list of cases that I would hear. But again, you can't guarantee that everyone will have notice. Presumably, they would have had notice of the death of the loved one, the person, and that they would follow up and say, well, is there going to be an inquest? But unless the coroner is aware that a person wishes to be notified, and it's open to her, anyone who has an immediate interest to notify the coroner that they would like to be advised of the hearing of the inquest, that they can do so, and they will hear about it that way.
All right, thank you very much. Yeah, and if someone does not have a person to support them attending the coroner's court, is there a service available that they can reach out to for support?
Well, apart from the I suppose HUGG, sort of, and the various Samaritans and other such bodies, I'm just picking two of those. The person or the persons who are most directly in contact with the family are the Garda liaison officers, and that is where their service is invaluable. Now, over the years, I did ask and did request at a number of inquest hearings that consideration would be given by the HSE and the health authorities and hospitals to the appointment of a bereavement officer in hospitals. Some hospitals do have it. I know that in the case of maternal deaths or infant deaths, that there often is a bereavement officer, but it doesn't apply across the board to all other deaths. And it seems to me that it is something fundamental that there should be in a hospital setting a bereavement officer who is in a position to provide the immediate information to a family or family members as to what is happening and what is likely to occur and how things are going to pan out. Because it does fall, as it at present, a great deal of it falls on the shoulders of the Garda liaison officer, who, as Stephen earlier mentioned, is appointed by the district officer, either the inspector or the superintendent. But that is a role that is not statutory, but it is a very important role. But in my view, there should be an obligation on the health authorities to have a bereavement officer in every area and in every district that's occurring.
Yeah, thank you. And what about legal representation and legal aid?
Well, there's two issues there, I suppose. One is legal representation. Everyone is entitled to have legal representation at an inquest. Sorry, that's what I say. Everyone who has a specific interest, the family are entitled. And where that generally is quite common is, say, a death has occurred as a result of injuries in a road traffic accident, or I have seen it in cases where a person has died by suicide, but there can't be a determination that a person has died by suicide until the inquest is held. And sometimes there's a misnomer that, the person has died by suicide. But I mean, that's wrong until such time as the verdict is recorded. That is not the actual situation. It is a sudden death that is the subject of an inquest. The end result may be a verdict, but I've often cautioned people not to refer to a death by suicide until such time as the inquest has been concluded.
Yeah. And what about support like translators and or media? Is it just sorry?
Sorry, no, go ahead. Yes, I mean, if there's a necessity to have a translator, then that the coroner can direct that one would be available. And increasingly, as we become multicultural, there are circumstances, and I held inquest myself where there was an interpreter there to explain to the family who are not English speakers or not fluent English speakers what was going on. So the coroner can direct that, and it will be done. You asked a question about legal aid. That is very restricted, unfortunately. It's again, it's administered through the legal aid system, the civil legal aid system, and there's without getting too complicated about it, some European legislation in relation to what they call Article 2. And for example, if somebody dies in a prison setting or in a setting where they are being held against their will, sometimes in, say, psychiatric hospitals, for example, and their means are such that they cannot afford legal representation, then they can apply to the coroner to certify that it is in the public interest that legal aid be made available. But it's not the coroner who grants legal aid. It has that application then has to go to the legal aid board, who are situated down in Kerry, and they make the decision as to whether or not a person is entitled to legal aid or otherwise. But coming back to the general question about legal representation, yes, every family member, every person who has an immediate interest in the inquest and the outcome of the interest is entitled to have legal representation. And in, I'd say, 50% of cases, it happens. Sometimes families just don't need it or don't want it. Often they have had an interaction with the coroner who's explained what will happen, or with they've had an interaction with the Garda liaison officer who explains matters to them.
And with the role of media, can the media just arrive in, or do people? I mean, how does that work?
Well, again, the coroner's inquest, like all courts in the country, except family law courts in certain cases where they're held in camera, in other words, held in secret, a coroner's court is a public forum, and anyone can go there. The media therefore are entitled to attend inquests. The experience that I had over 45 years as a coroner was that the local media, the provincial media, were very, very sensitive in reporting, or not reporting as the case may be, deaths by suicide, and invariably they did not do so. However, there were a number of cases over the years where I know the family specifically requested that the media would take cognizance of the actual death, because they thought that it would benefit others to know what happened in circumstances, and that it might be of some help to other families to avoid the actual death that occurred in their circumstance. But that was an exception. To answer your question, yes, the media are entitled to attend, but invariably the provincial media, certainly in the west of Ireland anyway, rarely report it. I do know that there's some high-profile cases in other areas, particularly in, say, urban areas, where there may have been reports, but again, it's not generally reported as far as I'm aware.
Okay.
And the other thing I just to mention is that I spent some time on the press council over the years, but they have a code of practice which they ask the media to follow in relation to reporting not just deaths by suicide, but also other deaths, tragic deaths particularly, and most of the media outlets in the country have signed up to that. So they follow the Press Council guidelines in relation to the reporting of deaths where there may be considerable difficulties for families, or they may be extremely traumatic.
Yeah. And Pat, I hope the questions are not coming on to you too fast there, because I feel like I'm just there. You're doing great. Well done. You're doing great. And what evidence is gathered for the coroner to review?
Okay, that's a very interesting question. As I say, just going back to the start, the coroner is advised and told about the sudden death by the Garda, and there's a form what's called C71 that's sent to the coroner. Then the coroner considers the circumstances and decides then, on the basis of the information furnished, who should give evidence in relation to the determination that the coroner must complete. That is, the identity of the person who has passed away, how, when and where the person has passed, and record a verdict, and then record the medical cause of death, and also then investigate the circumstances. Statements are taken by the Garda, and the Garda, in the circumstances of a coroner, act as agents for the coroner. They're unlike circumstances where most people would have an interaction with the Garda, where it's dealing with crime or dealing with sort of public order or dealing with road traffic incidents. The coroner is the person who directs, and all of the information is furnished to the coroner. The coroner is the person who makes the call as to who should be investigated and who should give a statement. So, generally speaking, there are a number of statements that are directed by the coroner. One is the family are asked to identify and to give a short statement to the Garda, but again, the investigating Garda, who is nominated by the district officer, the superintendent, to investigate it, will get a statement. Again, it's taken sensitively. Then, if there are other circumstances surrounding the actual death itself, that there may be witnesses, then a statement will be taken from them. And then, as I mentioned before, the pathologist's report is furnished, and the Garda is themselves, the investigating Garda, will prepare a statement. Those statements are then furnished to the coroner in a Garda file that's sent to the coroner. And the coroner, once he or she has the actual file in front of them, decides, first of all, what witnesses should attend the inquest, assuming that an inquest is to be held, and which of the witnesses who've given statements should be called. Those statements are draft depositions. That's the legal terminology for them. They are not conclusive until such time as evidence has been given at the inquest. The witnesses then are asked to attend the inquest. They give evidence on oath or affirmation if they don't take the oath, and they then generally the statements or the witness evidence is in accordance with their statement. There can be questions raised by either the family members if they have questions to raise for the witnesses, and then if the Garda have any further questions, they may do so, but they rarely intervene. And the coroner, of course, him or himself or herself, can ask questions, because bear in mind that the coroner's court, unlike other courts in the country, like the District Court, Circuit Court, High Court, are not adversarial or shouldn't be adversarial. They are an inquiry. They're an inquiry into the death, the circumstances of a person's death, the identity of the person, and also the medical cause of that person's death. Increasingly, there have been some reasonably contentious inquests where cross-examination got a little bit out of hand, but the court is quite clear that it really is up to the coroner to control the inquest and not to allow an inquest to become adversarial as the other courts are. So therefore, it's an inquiry controlled by the coroner. And certainly, I know my former colleagues would always be sensitive to excessive, let's put the word badgering of witnesses, because that does not lead, and it is not necessary to lead to the actual result that the coroner has to bring in, which is the verdict and the actual identity of the person itself. But then, having got the evidence, the coroner then will decide on, as I say, the identity of the person, the medical cause of death, and then record a verdict.
Okay.
And that's where it can be problematic, because simply because somebody died by their own hand does not necessarily mean that it was suicide, because the burden of proof is obviously to show, and it is necessary to show beyond all reasonable doubt that a person intended to take their own life. I won't go into the history of the law in that regard, because it goes back for quite some time, but the law is quite clear in this country still, and I know there have been suggestions for change, and there was an Indicon report prepared for HUGG, I think last year, that went through this in some detail, but it's still on the reasonable doubt, beyond a reasonable doubt, that the person intended to take their own life. If there's any doubt, then other verdicts are available to the coroner to record, whether it be an open verdict, in other words, it is not clear from the evidence what the actual circumstances were, or accidental, because somebody can go out and unfortunately have an accident, a serious accident. That could be misadventure, or it could be just simply accidental. And increasingly, though it's something that I didn't do much, but increasingly I see, and it's largely coming in from the jurisprudence in England and the north of Ireland, what's called a narrative death. In other words, recording what the actual death was and recording the circumstances, but not actually recording a simple verdict of either accidental death, misadventure, suicide, or an open verdict, as the case may be.
Yeah.
So
The question verdicts are available to be recorded by the coroner at the conclusion of an inquest. I think you've covered that there. Have you? What verdicts are available to be recorded by the coroner at the conclusion of an inquest?
Well, there's a number of verdicts traditionally that could have been recorded, depending on the circumstances. The most, or he's working to say the most common, certainly there can be a verdict of a death by natural causes. So that somebody just had a serious health condition or something suddenly happened to the person, they had a heart attack or otherwise. That would be natural causes, even though if they died in their own home or otherwise. But one of the purposes of the inquest is to allay public suspicion and public rumours in relation to it. Because so natural causes is one, and that is probably the most common. Accidental death, that's where somebody dies as a result of injuries received in an accident. The most common cause there would be, say, a person dying as a result of injuries received in a road traffic accident. Death by misadventure, that is where somebody does something that is dangerous, not intending to actually cause injury or death to themselves, but unfortunately does so. The usual example is walking a tightrope over a ravine. If you're not sort of geared towards it and you fall from that, then that clearly is misadventure. There are other circumstances as well. An open verdict, where it's not possible to determine from the information and from the evidence what the actual cause is. Sometimes families don't like that, because it does leave an air of suspicion that perhaps the person did die by their own hand, or that it wasn't accidental. It's a verdict that is not used or brought in that often, but it's still available. And then, of course, there is in the case of homicides, where there's an unlawful homicide or otherwise, that's a verdict, but that's generally dealt with through the criminal court system, and the coroner just takes notice of what has happened in the criminal courts and records the verdict that has been recorded there, whether it's unlawful homicide or otherwise.
Okay, and can family ask questions for the coroner to consider at the inquest? Are the
Oh,
family
yes.
Yeah.
Yeah, absolutely. I mean, and it's very important, I think, that
Yes.
people do ask questions, because at the end of the day, the coroner is there to try and bring that, and I don't like using the phrase, but it is used a lot, is bring closure for the family as to the circumstances of a person's passing. But it is very important that family members do ask questions, and it doesn't have to be done through a lawyer. They can do it themselves. The only, I suppose, restriction is that it's better if there are family members who are designated, not that you just have one person, but a few people. But what you don't want is a repetition of the same type of question, or you don't want, for clear reasons, you don't want to prolong the process. But if there are questions that need to be asked, they should be asked by whatever member of the family feel that they should ask the question, and the coroner will facilitate and should facilitate those questions being answered.
Okay.
There is one other matter, sorry, I should have
Yes.
mentioned earlier on, the question of whether an inquest is held with or without a jury. Just in the vast majority of cases now, inquests are held without a jury. That's by the coroner themselves. The jury process is quite cumbersome, and without going into the difficulties, it does create certain difficulties. There are some cases where coroners have no discretion. They must hold an inquest with the jury. For example, if somebody dies in prison, or if somebody dies in the control of the state, then they must hold an inquest. It's open to the coroner in any inquest to have an inquest with a jury, but invariably, I would say 90% of inquests now are held without jury, but by the coroner themselves.
Right. And if what are riders and recommendations and their purpose? Now, we've just got two questions, so this is the one before the last. What are the riders and recommendations and their purpose?
Okay, well, riders, I don't understand, but certainly recommendations are set out in the legislation. And basically, at the end of the inquest, the coroner records a verdict. And if the inquest is held with a jury, the jury themselves may make recommendations in relation to the circumstance of a death. But it's to deal in the broadest possible way in the public interest, to bring in general recommendations that might alleviate a circumstance that led to the death of the particular person. So the coroner, for example, it happens not quite a lot, but in a number of circumstances where there are road traffic incidents and deaths in road traffic incidents, the coroner may, with the jury or otherwise, make recommendations that the road in question should be examined by the Garda, by the local authority, and by Transport Infrastructure Ireland to see whether or not there is anything that could be done to alleviate the actual danger that contributed to, or was largely contributed to, the actual incident that occurred. In the case of suicide, and I appreciate that this webinar is focusing on suicide, there can be circumstances, for example, if somebody takes their own life while they're in hospital, and depending on the circumstances, again, there can be recommendations directed to the hospital authorities or to others that certain matters or certain procedures should be looked at to try and ensure that such an eventuality would not occur again. And that's really one of the purposes of inquests, is to try and learn from the tragedy of somebody's passing, which is always extremely difficult, but for the person and for the family, but to try and learn and see whether or not the circumstances are such that they would not be repeated to lead to another tragic death of the nature that occurred. So it's recommendations. The other thing that is very important to be aware of is that the law, Section 30 of the Coroners Act, is quite clear that no finding of culpability or responsibility can be made by a coroner or a jury in an inquest case. So, in other words, there is an express prohibition on making findings of any liability, responsibility, or culpability. That's a matter for another forum, if there is to be something out of it. But that sometimes is confused with the ability and the right of a coroner to make recommendations in relation to the circumstances that led to a particular death.
Okay. And if one wishes to make a complaint about their experiences within the coroner's court, who can this complaint be made to?
That's a very interesting question. I mean, the first thing is the complaint should be made by somebody who has an immediate stakeholding in the inquest and in the findings, and that should be made directly to the coroner themselves. Because in fairness, if you have a complaint about something, you should actually make it to the coroner. If at the end of the process and they don't get satisfaction, then it is very limited as to what can be done. You can, a person could make a complaint to the Department of Justice, because ultimately, while the Department of Justice wash their hands of involvement in the coroner's court and say that they don't have any actor involvement in it because coroners are independent judicial authorities. That's true, but it's when it comes to doing something that it is the Department of Justice that direct what's to be done. They direct the remuneration and they direct the services that can be provided by a coroner. So to answer your question, it is, I suppose, directly to the Department of Justice. However, there is another process which is called a judicial review. And if there is an inquest held where there may be slip-ups, and coroners are human as well, or there may have been a process that wasn't properly dealt with by the coroner from a legal perspective, then following legal advice, there can be an application made to the High Court for what's called judicial review of the process. It doesn't, it's not an appeal, because there isn't any appeal from the coroner's court. The only form of review is a judicial review to the High Court. Now, since the 2019 Act, the coroner themselves may, for a determination of a legal issue or that might arise, and it doesn't happen that often, may actually refer a case, what's called a case stated, to the court, but that doesn't apply to the family, generally speaking, unless a legal representative makes an issue in relation to some legal matter relating to it. So, to answer the question very simply, make the complaint to the coroner in fairness, ask them to explain whatever their issue is. I know in the past I had people, even before or after an inquest, ask for a meeting with me. I would meet with them and explain the matter to them. And by and large, I think most of my colleagues, my former colleagues, would do that. But if they're not satisfied there, then there's the other avenues that I've mentioned that are available.
Okay.
Deal with various, there were a number of others. Very simply, a coroner's inquest, a verdict or a verdict in a coroner's inquest cannot be appealed. I dealt with the issue of if there is a complaint about the manner in which an inquest is conducted, then there is the process to get a judicial review to the High Court. The other matter is the implication of verdicts with regard to financial institutions. And I did touch on that at the beginning. There can be delays in getting a state debt certificate, and most financial institutions, but not all, will pay out on a receipt of the interim death certificate that I refer to. That's the coroner's certificate as to the fact of death. But if a person needs some evidence of a person's passing, then the way to deal with that is to get the coroner to issue a certificate, an interim death certificate, and pass that on to the financial institution. Regretfully, there are some financial institutions that don't take that. They want to wait for the state death certificate, and that does delay matters, and it is very difficult for persons. Most Irish institutions do, the banks do, I know, insurance companies, but some of the English companies that are trading in this country don't do that, and that could cause difficulties. As far as bringing personal items into the court, yes, within limits. I mean, obviously, the family are very concerned. If there are personal items that they wish to bring to the attention of the coroner, they should do so. Photographs, of course, I've seen many times family members bringing photographs in, and I certainly had no difficulty with that. The one thing that is very important is that the coroner has to be mindful that there is a bereaved family, that there are family who are upset and traumatized by a sudden death, and that anything that exacerbates their grieving or their difficulties has to be under control and has to be controlled very, very carefully. As far as the implication of verdicts with regard to CSO statistics, that is something that I saw referred to, I think, in the Indicom report that was came out in June of last year. That's something that I haven't had any personal experience of, but what I do know is that there probably is, but I don't have any empirical evidence of this, there probably is under-reporting of death by suicide, but at the same time, and I saw some reference to there might be, for example, 550 deaths by suicide in Ireland every year. That could be under-reported to the tune of 100, 150. I don't know, but as far as the Central Statistics Office is concerned, they rely on information that's furnished to them by the Garda, and sometimes they will check back with the coroners themselves. And there can be circumstances where it's marginal as to whether or not a person's death was by suicide or otherwise. The principles and evidence used by a coroner in reaching a verdict of suicide, well, again, I touched on that, and that is on the beyond a reasonable doubt. I mean, beyond a reasonable doubt is where somebody clearly sets out to end their own life and leaves a note, and that's relatively straightforward. Circumstances of that person getting to that state of mind to do that is something that might be relevant to the coroner, but ultimately that would tend to lead to a verdict of suicide. There are other circumstances that can be problematic. For example, somebody falling down a stairs, following a party or otherwise, or following a row with somebody, that can be difficult. In most cases, that would be regarded as accidental rather than suicide. But generally speaking, where there is clear evidence on beyond all reasonable doubt that a person intended to take their own life, then a verdict of a verdict of suicide will be recorded. The other thing is the transcript of the inquest. I think you'd asked. Yes, but first of all, there's no transcript of coroner's inquest. The Department of Justice are fairly parsimonious in the service and the provision of services to coroners. Not only have they cut the fees paid to coroners in the last 15 years under FMP, but they failed to reintroduce that. They failed to provide proper secretarial backup services for coroners that are badly needed, and they have really failed to actually provide proper administrative structures for the coroners, and it is something that needs to be addressed, but not this forum tonight. As far as the availability of information in advance of an inquest being held, I have always had the practice that I would make available the draft depositions, that's the statements, and the post-mortem report to the immediate family. That would not be made available to everyone, because it is not conclusive until such time as the inquest is concluded. At the end of the inquest, when the verdict has been recorded and a certificate has issued in relation to the actual death, then the coroner's file, there isn't a coroner's file, but the coroner's records, that is the depositions, that's the statements, and the autopsy report, the pathologist's report, and the record of the inquest are available to the public and to members of the family. there can be a small fee charge in relation to that. There's some areas where it's exempted from the Garda, you don't have to pay for it, or other state agencies, but by and large it can be made available. In the case of a coroner, the coroner will hold their files and records until such time as they either retire or resign. In my case, I had nearly 100 years of records recently to pass on to the county registrar. It is the county registrar who then, once a coroner has retired, who must or should be asked for the records of the coroner, and they are available again from the county registrar's office on payment of a relatively nominal fee, but they are available. They're public records simply because the inquest has been held in public, in the public interest, to allay fears and allay suspicions and rumours.
And there's no time, is there a time period as to how long back you can go?
No, there isn't. But you know, if you go too far back, you might find that records are difficult to obtain. But I know in my case recently, our records go back to 1950 when my father was coroner, from up to 1988 when he was the coroner, and I have records from 1988 up to 2024 when I ceased. My son carried on for a few weeks, but then the Department of Justice, in their wisdom, decided to merge the entire of the county. So our records will be sent to the county registrar in Mayo, but there's no time limit on going back to get them from the county registrar.
Thank you. And thank you very, very much, Pat, for an extremely informative response to all those questions. I really appreciate that. Thank you.
No, my pleasure. And I hope it allayed the fears and answer some of the questions of those, because at the end of the day, it is the family who have the questions. There aren't always answers to every question. And questioning is something that really persons have to come to terms with the support of organisations like HUGG and the Samaritans and Pieta House and other organisations like that.
Yes, absolutely. Thank you so much, Pat. I really appreciate it. And I'm sure that all of your listeners are here do as well. It's very informative. Thank you. Okay, so I'm going to let you go now and turn off your video.
I'm definitely gone now, am I?
Yeah. Thank you. So you turn off, thank you. So I'm going to welcome you all back here now, and I'm going to invite Mary McEwen now.
Thanks, Yvonne.
Hello, Mary. It's lovely to see you. And Mary is, I will let you do all the talking now.
Thanks so much for hosting that really interesting conversation and, you know, getting through such an amount of questions. I'm really mindful we have nearly 200 people with us on the line, and thank you for everybody for staying with us. We're very mindful of how difficult this particular topic is. And how sensitive it is, and I'm going to take you through. I'm very conscious of how much information we've heard, so I have 4 slides, and they're really visuals, and I'm going to take you through those 4 slides to give you a small piece of information about how HUGG can offer support to anybody bereaved by suicide. And if you want to grab a pen and a piece of paper, I will give out all our contact details. So I'm just going to share my slides. We offer support after suicide. We are the National Suicide Bereavement Organisation in Ireland. We offer comfort, support and hope to adults bereaved by suicide, whether their loss is recent or many years ago. And we do this by providing practical information and resources and emotional support through a range of activities and events, through our website, our telephone support line, and our nationwide suicide bereavement support groups, which are all led by trained volunteers with a lived experience of suicide loss. We received many questions from attendees for this evening's webinar related to supporting someone bereaved by suicide. Too many to answer with this time frame that we have for this evening, and the focus being on the coroner's court. So I would encourage anybody seeking specific advice and information to connect with HUGG telephone support line. Here you can see the locations of our dedicated in-person suicide bereavement support groups, which are nationwide. And we also have a virtual support group that people can join if there's not one in your region. In addition to these support groups, which are held regularly, We offer other types of support, including a HUGG walking group, pop-up suicide bereavement support cafes, and an annual suicide bereavement remembrance event, among other things. All of our services are free and offer social connection in a welcoming, non-judgmental space in the company of those with a shared understanding of suicide loss. Our support services offer you the opportunity to take some time for yourself, to share memories of your loved one and receive support, or simply just be in the company of others who truly understand. I would ask that you do connect with us. If you wish to learn more about HUGG support services, or if we can offer any practical or emotional support to you, or guide you on how to support someone bereaved by suicide. You can leave your name and your number on our monitored answering machine at 01 513 4048, and a member of the team will give you a call back, or you can connect with us through our email at support@hugg.ie. We are so grateful that you've taken the time to learn a little bit more about HUGG and join us this evening. And I'm going to share a slide with other support services that are also available.